This is a video on the basics of the trust law. Now, before we really start discussing what a trust is, it's crucial that we understand what the ownership of a property is composed of. A person is the owner of a property when he holds the legal title and the equitable or the beneficial title to it. Thus, when a person holds the legal title and the equitable title of a property simultaneously, he becomes the absolute owner of the property. By virtue of the legal title, he is the legal owner. Likewise, by virtue of the beneficial title, he is the beneficial or the equitable owner. You may remember this concept from land law, where in co ownership, we would see that it would only be up to four co owners that could be registered as the legal title holders. The co owners in excess of the four legal title holders be registered merely as the beneficial title holders or beneficial owners. The legal title holders would hold the property on trust for such beneficial owners. The trust law may be applicable to much wider situations and not merely just co ownership. Moving on, having understood this, a trust is formed where a person ceases to hold the legal title and equitable title simultaneously. Be that the person passes on the legal title to one person and the equitable title to another, or may just pass on the beneficial title or equitable title to somebody else, keeping the legal title with himself. Thus, when a trust is formed, the legal title goes to the person who is referred to as a trustee. Beneficial title of the property goes to beneficiary. The split of the legal title and the beneficial title holding amounts to a trust. Therefore, a trust is an equitable mechanism by virtue of which rights, whether those rights are personal or proprietary, are held by one party for the benefit of the other. Putting this further into context, a trustee holds this legal title on trust for the beneficiary who holds the equitable title. For every trust, there are three main parties. First is the settlor, another is trustee, and lastly, the beneficiary. A settler is the one who is the person that initially owned the legal and beneficial titles. When the settler divests himself of the beneficial interest or the legal interest as well, the person he passes on the legal title to is called the trustee. The person he passes on the beneficial title to is known as the beneficiary. Now, trusts in general are irrevocable. A settler cannot later change his mind and recover the property. This rule comes from Ray Bowden. It is the wording of the documents in which a trust arises. This helps determine whether a trust exists or not. This has a lot to do with the certainty of intention, which is one of the three certainties required for a valid declaration of a trust. Now, it is important to understand the types of trust that exist. We have two major categories: implied trusts and express trusts. The implied trusts have further subcategories: resulting trust and constructive trust. Express trusts have further subcategories of fixed trust, discretionary trust, and pair trust. Fixed trusts are those where the terms in the trust document are certain in full whether, to whom, and in what proportion will the property be distributed. Discretionary trusts, on the other hand, include some discretion that lies with the trustees. Beware of a similar concept of mere powers, also known as power of appointments. Resulting trusts are the trusts whereby property is to result back to the settler for one reason or the other. Constructive trusts, on the other hand, arise where there is a fiduciary relationship between the parties or there is some indication as to such common intention that a constructive trust be created. Courts, in finding constructive trusts, seek to engage the conscience of the settler.